Yes, my lord. I appear in 103
Yes.
and 102.6.
Yes. What are these matters?
These are matters, my lord, regarding regularization of assistant professors in 571 government schools. Would your lordship take my written submissions, please, my lord? That is document 17673 of 25.
All the petitioners are present. All the counsel for the petitioners are present.
आइटम नंबर 2 में मिस्टर पटने नॉट अवेलेबल है अभी।
तो फिर कब अवेलेबल होंगे?
लंच के बाद मेरा पास ओवर
It has to be decided finally.
Lord, sir.
Yes, my lord, we can. Readings are complete.
डेट बढ़ गई
कितनी petitions हैं?
अभी डेट
10 minutes.
So in all the matters, Mr. Patel is appearing.
नो मैम आइटम 14123
All the matters are depending on the 1.2.3, my lord, which is the senior advocate.
What is that?
That all the cases are seeking regularization on the post of the assistant professor. So it's 1.3. This will govern all the.
Who is appearing? Who is the petitioners' counsel in this?
I am the local counsel and senior advocate Dr. Colin Gonzalez in 102.3 and 102.6.
102.3 and 102.6 may be treated as a lead matter, my lord.
Yes.
110.
We are fully ready for final arguments in 30 minutes. 30 minutes we'll finish final arguments. No, my lord, I've been granted interim relief in 102.3. They are aggrieved by that. They want to change that. I want to defend it. And I want to also straight away argue for regularization.
Yes, because this 102 matter, the relief has been, interim relief has been denied. While order dated 30.
That is the connected matter, not mine, my lord. 102.3 grants the relief. That is order dated 16/10/25.
102.4.
ठीक है, फिर सुन लेते हैं इसको. Everyone is here. हाँ. अगर फाइनली सुन रहे हैं ना? They are all
Yes, sir.
in the same issue, ना?
Yes, my lord, identical issue.
That petition I am not seeking regularization because that petition is different. That petition already has been.
हाँ.
Subsequently, that has been application also they were trying to replace it. So this petition was filed also challenging certain the advertisement that has been issued by the state for appointment of the regular appointees in our place. We are working for last more than a decade. I guess.
All right, but these are the matters. You are identical matter, na? You are also a guest specialty.
Is about people.
You are objecting to posting of the regular professors, assistant professor in place of you. That is the only question.
What in fact to happen?
Yes.
Now the state is, they have very recently they have issued a circular saying that we will give them, we will accommodate them to some other place if a guest faculty, if the regular appointee is being replaced, if the guest faculty is being replaced by the regular.
हाँ तो देख लेंगे ना.
Yes, my lord.
ये सुनने दीजिए.
Yes.
सुन लेते हैं.
And my learned friends who speak into the mic, my lord, is difficult to hear when they speak from far. But I'm ready, my lord. We can start if you permit me.
He's appearing for some other candidate with
Yes, sir.
having the same grievances as of you.
Yes, sir.
So he's asking for the interim relief. It is his first, I think, hearing. So let it be decided finally if all issues are identical.
Yes. I'm ready, my lord. Same argument for interim, same argument for final. 30 minutes.
Are you ready, State Council?
Lordship, I am ready. But as if the last order may be seen, we were directed to
1.2.102.3.
we were directed to supply a copy of this circuit. These are
That is document. Regularized people, my lord. So, my lord, 2024 is like a demarking demarcating point where the Supreme Court has embarked on a different journey and has not allowed people who are qualified and so on to be kept for such long periods of time.
Yes.
And particularly teachers, my lord, where recently the Supreme Court has said teachers are the backbone, the intellectual backbone of the nation. So I'll come to that, my lord. So, my lord, 291 assistant professors. In the companion petition, my lord, again, there are similar numbers. Altogether, roughly 500 assistant professors, all of whom have PhDs. And if your lordship goes a little down in paragraph number 1, they are paid in a month after 20 years of service, no provident fund, no gratuity, no statutory benefits at all. This manner of keeping staff, academically qualified staff, with unblemished service is itself manifestly arbitrary. State government has done something very wrong. Article 14, arbitrariness. Now, my lord, look at the next, look below kindly and see from the point of view of balance of convenience, just to bring us totally 12,000 sanctioned posts in 571 colleges. 6,298 sanctioned posts are vacant. Such a large number of vacant sanctioned posts. And yet the state is pressing that the interim relief granted to me should be vacated, and they will make a suggestion to your lordship about the fallen out system, which I will deal with. Regular recruitment is going on for 2,100 vacant posts. So out of 6,298, regularization process is starting for 2,100, which means, my lord, a very large number of posts are vacant, and there is no need absolutely for any of the persons who are covered by your lordship's interim order to be considered for removal or vacant, fallen out and so on. There's no pressing need at all for that. Anyway, allowed you finally today. Now, my lord, kindly turn the page. Where I, my lord, make the point that there is no need to terminate, balance of convenience is in my favor. The list of the vacant sanctioned posts, my lord, is given at page 506. It shows 12, this is a repetition, it shows 12,000 sanctioned posts, 571 colleges, 4,500 are presently occupied by contractual guest facility like mine, my lord. 6,298 remain vacant, and the recruitment is only going on for 2,100. There is no reason why all the contractual assistant professors cannot be regularized. Because even after you regularize me, you can carry on with your regular recruitment for 2,100. Now, my lord, what is this case about? The other side says
What are the numbers of these guest faculties against this section post?
It's written here, sir. 4,500 are working against sanctioned posts. Which means out of 6,298, if you deduct 4,500, there are a large number of sanctioned posts available even for the fresh recruits. There's no problem at all. And the state's urgency, my lord, is not understandable. Why they should be so determined to throw out people who have 20, 25 years of unblemished service.
To replace
Now, my lord, the main point. The state will tell your lordship that the main point is regular recruits are being appointed to replace temporaries. Temporaries with 20, 25 years. That is their way of putting it. But in view of the latest judgments of the Supreme Court, Jago and so on, I would frame it differently. Jago and a line of decision say that once they have put in long years of service and they are qualified and have got the required any complaint, their temporary status will no longer apply in law. They must be reclassified. Different terms are used in different judgments. They must be reconsidered as regular. Your terminology will not prevail, and the court and the law will treat them, notwithstanding your nomenclature, as regular employees. Therefore, what is this case about? Regular employees with 25 years service being replaced by regular employees with 0 service. That's the sum and substance of the factual context. So, my lord, that I set out. And my lord, at page 3, I give you, my lord, the propositions found in these judgments. Though the nomenclature is temporary, they are in law and in fact regular teachers of the state government. They are therefore liable to be regularized. That's one phrase used by the court. Second is recognized. The court must recognize them as being permanent, not temporary, etc., etc. Now, my lord, Jago, page 3, my lord. And I'm quoting from the judgment, and this is at page 195 of the compilation where the judgment is there, my lord. But I'm reading the excerpt. Despite being labeled as part-time workers, the appellants performed their essential task on a daily and continuous basis over extensive periods, ranging from over a decade to nearly 2 decades. Mine is even worse. 2 decades and more. Their engagement was not sporadic or temporary in nature. Instead, it was recurrent, regular, and akin to the responsibilities typically associated with sanctioned posts. Moreover, the respondents did not engage any other personnel for these tasks during the appellant's tenure, underscoring the indispensable nature of work. They could petition my work. Paragraph 13. The recurring nature of these duties, this is the important sentence, necessitates their classification as regular posts. Recurring, you will be classified as regular posts, irrespective of how their initial engagements were labeled. The appellant's consistent performance over long tenures further solidifies their claim for regularization. At no point during their engagement did the respondents face any issue regarding their competence or performance. On the contrary, their services were extended repeatedly over the years. In our case, on a yearly basis, the reports are taken, their evaluation is done and continued. 20 years, again and again, they are put to some kind of analysis and assessment. On the contrary, their services were extended repeatedly over the years, and their minimum was incrementally increased, which was an implicit acknowledgement of their satisfaction. The respondents' belated plea of alleged unsatisfactory service appears to be an afterthought and lacks credibility. This is also applicable to us in the fallen out system. Today, you'll say after 20 years, there's some, let's see, my lord. Paragraph 19. It is evident from the foregoing that the appellant's roles were not only essential but also indistinguishable from those of regular employees. Their sustained contribution over an extended period, coupled with absence of any adverse reward, warrant equitable treatment and regularization of their service. Denial of this benefit followed by arbitrary termination amounts to manifest injustice and must be rectified. It is well established that the decision in Uma Devi, which, my lord, is their trump card, they think, but Uma Devi is also totally in my favor. It is well established that the decision in Uma Devi does not intend to penalize employees who have rendered long years of service fulfilling ongoing and necessary functions of the state or its instrument. The said judgment sought to prevent backdoor entries and illegal appointments that circumvent constitutional requirements. However, these appointments were not illegal, but possibly irregular, and where employees have served continuously against a background of sanctioned functions for a considerable period, the need for fair and humane resolution becomes paramount. Prolonged, continuous, and unblemished service performing tasks inherently required on a regular basis over time. It is disconcerting reality that temporary employees, particularly in government institutions, often face multifaceted forms of exploitation. While the functional purpose of temporary contracts may have been to address short-term or seasonable needs, they have increasingly become a mechanism to evade long-term obligations owed to the employees. In light of these considerations, it is our opinion, it is imperative for government departments to lead by example in providing fair and stable employment, Engaging workers on a temporary basis for extended periods, especially when their roles are integral to the organization's functioning, not only contravenes international labor standards, but also exposes the organization to legal challenges and undermines employee morale. By ensuring fair employment practices, government institutions can reduce the burden of unnecessary litigation, promote job security, and uphold the principles of justice and fairness that are meant to. This approach aligns with the international standards and sets a positive precedent for the private sector to follow, thereby contributing to the overall betterment of labor practice. Now, my Lord, Vinod Kumar, which is at page 247 of my compilation, and this is, my Lord, my extract. Having heard the arguments of both sides, this court believes that the essence of employment and the rights thereof cannot be merely determined by the initial terms of employment, when the actual course of employment has evolved significantly over time. The continuous capacities of regular employees performing duties indistinguishable from those in permanent posts, their selection through a process that mirrors that of regular recruitment constitute a substantive departure from the temporary and scheme-specific nature of their initial engagement. Moreover, the employment's promotion process was conducted, and with that, my Lord, is factually on the basis of those facts, my Lord. Turn to the next page, paragraph 8, my Lord. In light of the reasons recorded above, this court finds merit in the appellant's arguments and holds that their service conditions has evolved over time, warrant a reclassification.
Sir, just a minute.
The earlier judgment said...
Just a minute, sir.
Yes, sir.
Just a minute.
Yes, my Lord.
Counsel,
Yes, sir.
yes, sir.
I sincerely apologize for the interruption, Lordship. But if this matter may be seen that is being argued right now, there are several defaults, Lordship, that have not been cleared till date.
Because all of them have been cured. Register is not updated. I cured them yesterday only and before.
Yesterday, but still, Lordship, that needs to be verified.
Part is showing in the call list maybe.
Yes, all of them have been.
And even the intervene application is also filed, so that is allowed or not allowed.
Not in every case the default is showing, Lordship.
But
I've been cured.
so cure the default.
अरे तो ये interim relief has been granted.
The intervene application is also filed. Lordship.
अरे IR has been granted in this.
No, in this IR has been granted. Not in every matter.
But Lordship, once the default may remove, then
This submission was not made by them on the last date of.
he has not removed
They
the
are just trying
default
to find
petition.
out.
The defaults have been removed. Defaults have been removed, my lords. And secondly, there was an IA for ignoring defaults, my lords, already.
No, but
On the last date of hearing, they did not raise such objection.
there is no reply in this.
No. 102.3, they have filed their reply.
We have filed our reply and
Yes, my Lord, reply is filed.
Not in every petition, not in my
Ready
petition.
for hearing, ready for hearing.
Lordship, some of cases reply has not been filed. Some of cases only replied. So we are adapted these reply, but once the procedure may complete, we are adapting the replies that is distinguishable or not. So if they are sure, then we'll properly adapt. But
We
once
have seen their reply and we don't want to fight. So we are absolutely ready.
but
Meetings are complete.
but some of cases reply has not been filed.
But the thing is, now if you have filed a reply, where is the question of default now?
Yes, my lord.
But Lordship, we will file the reply once. But another thing is, Lordship, once the default is pointed out by the registry, then they may cure. We will file the reply by this enable court. Once the notice has been issued, we will file the reply. But once that they may cure the default, this is the procedure of the registry.
No, but have you,
Otherwise, they may move the application. For noting the default.
Already on record.
Already they're on record.
That is not allowed.
अच्छा ये बताइए किस किस पे रिप्लाई नहीं है आपका?
0.5 में तो नहीं है सर.
0.6 में भी नहीं है, my lords.
So many cases we are not, even we are adapting. But once
102 point कितना है?
सब तो डेट में दी है.
Also, in 2-3 cases reply is there, but majority of the cases reply is not there.
It's not there.
No,
So what you have done about that?
Lordship, we'll
But
file.
it's our time, Lordship, we will file the reply or adopting those replies. But
They can adopt that.
अपना तो खत्म ही हो गया अपना तो खत्म ही हो गया
They are moving the English release. And Dr. Malar matter has been put today Malar for final hearing. Now he is opposing for final hearing.
And their BS Tony matter was kept for
Yes, Lordship. And they did
On
not.
the last date of hearing, my lord, on the last date of hearing, the state was opposing tooth and nail, my lord. And they were even, my lord, they were shy of hearing before your lordship today, my lord. For the reasons best known to them, my lord. All kinds of lame excuses are being taken now that the default and all. Nothing was pointed out on the earlier date of hearing. They were so keen to argue the matter that the Honorable Court was pleased to fix it with a date and the time specified, my lord, that it will be heard at 12 o'clock, my lord.
When the duty of the petitioner lordship, they may remove
They ought to have
duty
raised
of
such objection
not
on
the
the last date
respondent.
of
So
hearing.
once that they may remove the default, then argue the matter. This duty of the petitioner, BR point out or not, this is issue of the petitioner. Once they remove the default, then argue the matter in the final.
There is
My
a
learned friend is assuming the role of the registry as well before your lordship.
Just a minute, even assuming that there was some default, but when you have already filed a reply, there is no question of now those default to be considered.
And even though
Exactly, my lord.
the cases reply are not filed. So we will file the reply.
If defaults were concerned to you as a state, if they are not, if they are concerned with the registry, they will be taken care of, or if it has already been taken care of
Yes,
or
sir.
not taken care of,
Yes.
see to it.
Yes.
Now the question is that once you have filed the reply, where is the question if those defaults are concerned with you?
Lordship.
You are not able to read the copy,
Lordship.
then we could have understood. Now you have already
Yes.
filed the reply, there is no question.
Lordship. And another thing is, Lordship, in so many cases reply has not been filed. So we will adopt the reply, but once maybe time, Lordship, short time we will file the reply, and adopting or not adopting, so we will decide,
How
Lordship.
many cases are
But
there?
that prayer was made on the last date of hearing and they have posted. In fact, my lord, it was listed on the insistence of the government council today, my lord.
and without issuance of notice on the insistence.
Even though, Lordship, this is the 225 cases, Lordship.
My case. Just wanted to make a request, Lordship. My case was listed along with the main cases, Lordship. On this, they insisted me to list this case along with the main.
5 Lordship.
तो भाई तो पर आपको तो ये with clear understanding the adjournment was granted that no
Yes.
see the
Yes.
order sheet
But it is not prejudicing my today.
14/11/2025. Please see the order sheet.
Yes.
Just a minute. Who had appeared from your side?
It was
So
Lordship, in earlier date, this Honorable Court not mention the event presence, but they are present.
then
Mr. K.
what did they do?
Mr.
If they had to file the application for adopting the reply,
Lordship,
why they have not filed it?
even those may kindly see the order sheet, Lordship. Once the matter has listed on dated 16/10/2025, this Honorable Court has issued notice to the respondents. And again, matter was listed dated, Lordship, 30/10/2025, in which this Honorable Court has directed the interim leave shall be maintained and matter take up on so and so WP. And next date, Lordship, 14/11/2025, even they may requested before the court the matter should not be adjourned or whatever. So,
they have to file a reply. But
so therefore, in third date, Lordship, even in third date, Lordship, they may requested before the court or matter should not be adjourned
He did not
next date.
so request for an adjournment.
Only I'm seeking the opportunity, Lordship, we will file the definitely reply each and
Please, my lord.
so Bill,
At least, my lord, in my matter where the pleadings are complete, let us finish because the pleadings are complete. There's no disagreement at all. And after hearing me, my lord, actually, I'm covering most of the points.
So we will
Then if there's any stray arguments, then they can do some stray arguments. But at least our matter we can finish today. I told you, lordship, in 20 minutes, 25 minutes, I'll finish.
So tell me the numbers in which you have not filed.
Lordship.
Where is the application?
रोज एक पिटीशन फाइल होगी माइला तो रोज ये दो एक टाइम लेते रहेंगे
नहीं तो एक पिटीशन फाइल होगी तो हम पिटीशन का रिस्पांस तो देंगे, चाहे ड्राफ्ट करें चाहे ऐसा थोड़ी कि बिना पिटीशन के रिप्लाई के नोटिस करा लेंगे और हम जवाब दें, नहीं जवाब नहीं देंगे।
Mine is a fresh case.
रोज पिटीशन एक फाइल होगी तो हमको तो रिस्पांस करना पड़ेगा, फॉर्मल करें।
आप ये तो बता दीजिए आपने किस में आपको आरोप करना है।
मैं नहीं, उसको देखना पड़ेगा किसमें वो एडाप्ट होंगे रिप्लाई, किसमें नहीं होंगे सारे केसेस में। अगर एडाप्ट हो जाएंगे तो हम कर लेंगे, हमें कोई इशू नहीं है, लेकिन हमको इसको एक बार उसको देखना पड़ेगा कि किन किन केसों में एडाप्ट हो जाएंगे।
देखा क्यों नहीं 14/11 से?
14/11 लॉर्डशिप इन द डे बिफोर स्टार्टेड लॉर्डशिप।
तो दिन देना देख लेना चाहिए था आपको.
On the last date of hearing, it was their submission that the reply filed in one of the case would take care of all the writ petitions, my lord. This was their stance before the honorable court.
So actually now means why you have not done it within these 2-3 days, or you should have taken more time.
Lordship, even though call the YC, Lordship, they file the affidavit, formal or not, but affidavit necessary. So many districts are there, so we will file the reply.
तो आपने चिट्ठी लिखी है चौथा शाह के पास? को
मैं देख लेता हूँ.
फोन किया उनको? वो तो सब रिकॉर्ड आजकल तो सब लिखा हो, फाइल पे लिखा रहता है.
हाँ, लिखा रहता है, फाइल में सब रहता है.
वो IC भोपाल से कह रहे हैं.
आप आ गए क्या वो? आज तारीख लगेगी तो आ गए क्या वो?
नहीं, मतलब सेम हो
बुलाया नहीं आपने? YC को नहीं बुलाया?
YC, Lordship.
तो क्यों नहीं बुलाया जब 14/11 को लास्ट डेट पूछी तो आपको?
हाँ, Lordship, that.
क्यों नहीं बुलाया? किसने इन्फॉर्म किया? इन्फॉर्म किया कि नहीं किया?
वो मैं देख लेता
Lordship, will.
कि आप अपने मन से टाइम ले रहे हैं?
No.
नहीं, ऐसा नहीं है. बिना जवाब के ऐसा थोड़ी होता है.
It is.
On one hand, they have made an application for transfer.
अरे वही तो कर वो
Maintain the decorum before the court, Lordship.
तो इंस्ट्रक्शंस है क्या आपको?
नहीं, even once the in one case
तो फिर वो 14/11 में जो वकील साहब उपस्थित हुए थे उनको नहीं मालूम था कि सब में जवाब देना है? Why he was so casual before the court? If he wanted to file the reply for all the matters, he should have stated in all the other matters we have to file reply. There is nothing in the order sheet. In fact, there is an observation that no adjournment shall be granted to any of the party.
But I'm not saying for that, Lordship, but only I am requesting, I am only praying, Lordship, maybe take up the next week, Lordship, we will adopt the reply.
I am granting you only a week's time.
A week's time.
The next week.
Lordship, definitely.
Whatever you are required to do
Yes.
it. I am observing this.
Lordship.
That you are seeking time to either file an application or adopt
2.7.
file a return.
Lordship.
If no return is filed or no application is filed, matter shall be heard.
Lordship.
Because there is already an order by this court.
Lordship.
You could have been vigilant at that time only.
Lordship.
आज जो आप कर रहे हैं तो वो उस दिन क्यों नहीं किया आपने?
What has happened in my case, Lordship, they insisted to link it along with these cases. Now, on that day, therefore, the notice was not issued by this honorable court and no order of interim relief was passed, Lordship. Though my case is identical, similar to the case of 291 employees, and in my petition, only one singular employee is there. Filing till the reply for next week, then the interim relief may kindly be extended.
No, I am
my
giving
case.
them only a week's time.
Yes,
Because they say that in all the other matters they have not filed the reply and the council is insisting that they have to take instructions in the matter. Because
Yes,
I don't know all the matters the notices have also been issued or not. So in all the matters I am directing them to either adopt the reply which has been filed in your case or file a separate reply by next date of hearing.
Yes, my lord.
And no adjournment shall be granted.
Yes, my lord. And we'll straight away go ahead on that.
Well,
date,
there is
my lord. No,
there is one more there is one more submission, my lord, in item number 102.7, my lord.
Yes.
My lord, 102.7 was a fresh matter, my lord, wherein the relief was one identical with that of these 291 people, my lord. We are seeking regularization on the strength of the judgments of the Honorable Apex Court and on the basis of our long stint with the respondent number 1 department, my lord. In our case, my lord, the order of status quo regarding maintenance of our appointment has not been passed, my lord, because of the understanding of the fact that it will be heard on Monday today, that is today, for finally, my lord. So if eventuality, in that eventuality, my lord, if lordship is extending the benefit of time, my lord, to the respondents, my lord, I may pray for the similar interim relief as has been granted in the main lead case, my lord. Otherwise, the very purpose of filing the petition would render infructuous. They will be thrown out of the employment, my lord.
Same prayer.
Suppose if your petition is allowed in entirety,
Lordship.
they have to consider your regularization.
My lord, but in that eventuality, I would not be in the system at all, my lord.
Because you are
For claiming regularization, one has to be there in the system, my lord.
on that day you would not be in system, you would be before the court. The court can address and order them to consider your case. If
My lord, still, my lord,
if your petitions are allowed.
But
My lord, still I request your lordship to, at least for the maintenance of parity, my lord, that I am claiming that interim relief, my lord, has been granted to all other persons, my lord.
because we are still.
All identical relief, my lord, identical circumstance, people working against the sanctioned force for years together, having qualified service, having qualification rendered to them, my lord, and covered squarely by the Uma Devi judgment, my lord.
Next date of hearing.
Lordship, that
Only till the next date of hearing, my lord, I am not seeking it should be.
interim was already rejected. In the main matter, your lordship has already seen the order. In the main matter, lordship, not in connected matters. Your lordship has seen the order. Very clearly, it was stated that a state of chaos will be created if.
No, it is only with the understanding that on Monday it will be heard. That is why we did not insist for the grant of interim relief at the relevant point of time. Now it's a complete somersault by the state, my lord.
Just a minute. So this was not brought to the. अच्छा ये कब का है? बोला this. So this order was not brought in the notice of the court. This is
It was, my lord, and in fact, on that day the matter was segregated.
By this enable court.
But your lordship, by giving proper reasoning, the interim has been rejected. It's ordered.
It's passed yesterday night.
48061 is the lead case, my lord.
In that case, lordship, there is still the interim order persists.
And please, thus, Patru.
665.
On that purpose, my lord, we have still pending for the DB, my lord. Our matter is listed today. That order has been challenged before the DB.
And still the defect has not been cured by the state in that writ appeals.
that you have challenged in the this thing. That is listed today.
Yes, my lord. Only in respect of the interim order.
I believe, lordship, the regular professors might have been appointed in their place. Up till now, as of now.
Now they are characterizing or designating it is as irregular or illegal, whatever.
Maybe fact is
File return or
Lordship will
file
be
application before next date of hearing.
will be.
I will pass it on.
Well, the status
And
quo by
sir-
that time, my lord, till the next date of hearing.
So, my
As
lord,
it obstains today, my lord.
in my matter 102.3,
Parity,
please continue the interim order till next week. And in 102.6, notice has to be issued and they may waive service because I've served them already.
Yes, yes.
Mine's
All the cases, I will direct the state to file the reply. So that will waive off the condition of PF and all that.
but they may not
Because
direct.
now in the lead matter, they have already filed the reply. Either they have to file an application for adopting it or to file a separate reply.
Yes, my lord. And in 102.3, please say interim order to continue
In every
till the
case,
next week.
they are all connected, relating to the same matter, and the state government has given undertaking that they will file the reply.
Definitely, Lordship.
So now that there is no question of passing the order of PF and all that and notices and all that. They will file the reply.
But there is an order of status quo in favor of 291 employees. My petition, there is only one employee, lordship. And only I am seeking to maintain parity in respect of one employee, which is existing.
Only till next date of hearing, my lord, will not claiming anything further, my lord. Only till next date of hearing.
Lordship, and
Which is operating in favor of 291 employees, lordship. Only one employee is there.
They are just publishing the interview list in which the person who are already under challenge petition, but they are removing that person in place of the regular person.
They will declare us fallen out. They will declare us fallen out. And they will any day without issuing any notice, lordship, they are removing us and the regular appointees is coming to the place
That
and he is
is
joining
in
us.
accordance with the policy of the guest faculty that no notice is
I will
required.
see now. Let's take the next. I will pass the order.
It will give down proper period for the matter.
Sir, and in 102.3, your lordship will extend it till the next day.
If it is extended, lordship, so request. Then that may be extended.
Lordship is fixing any particular date, my lord.
Yes.
That may be extended.
I am giving them 7 days time, and then I will fix it on a day.
Obliged. Grateful, my lord.
Can your lordship have 27th November if it's convenient to you, my lord? Only if it's convenient.
27th? All right.
Grateful, my lord.
Much obliged.